I'd like to get started. There. Hi, welcome. I am so pleased to welcome you to this gathering on behalf of the Unhoused Initiative here on campus and the Markkula Center for Applied Ethics. I'm really pleased to welcome you to this event. I'm Michelle Oberman. I'm a professor here at the law school and also a member of the Unhoused Initiative. We're an interdisciplinary faculty group, a collaborative group that's been focused on engaging the campus and also finding ways to serve and engage with the community around us so that Santa Clara can have an active and meaningful, intentional role in the local response to homelessness. We're grateful to the law school, to the College of Arts and Sciences, and to the Markkula Center for co-sponsoring this event for us and for the support that they've shown our initiative over the past few years. Before we get started today, just a couple of housekeeping bits and pieces. For those of you sitting here in the room, you'll notice a little index card that's there in case you have questions during the program. We're going to endeavor to leave time for questions and answers at the end, so you'll fill them out and ultimately pass them to my colleague David DeCoste here in front. For those of you who are looking for MCLE, Continuing Legal Education Credit, if you're attending by live stream, please email unhousedinitiative@scu.edu with your name and bar number, and we'll send you the MCLE certificate and the link to the substantive materials for the class. You'll find that email actually on the poster that's actually on the slide here. The poster for the program, the Unhoused Initiative email is at the bottom. For those of you that are in the room and wanting credit, there's forms that are right here on the desk, along with the substantive materials that you can find through that same Unhoused Initiative link. About our speakers, to my far left is Jeff Selbin. He is the Chancellor's Clinical Professor of Law at Berkeley Law School, where he co-directs the Policy Advocacy Clinic, which he founded in 2015. It's an interdisciplinary clinic where law and public policy students team up to take on systemic racial, economic, and social injustice. Before that, he worked for 25 years at the East Bay Community Law Center. It's Berkeley's civil legal aid clinic, rather. He's represented people experiencing homelessness on a wide range of legal issues and has published numerous reports about homelessness in California on behalf of the Western Regional Advocacy Project. More on that in just a moment. Next to him is Tristia Bauman, who started her legal career as an assistant public defender in Miami-Dade County, where she represented hundreds of unhoused folks accused of crimes. She then served as a senior attorney at the National Homelessness Law Center in Washington, D.C., where she litigated federal lawsuits challenging the criminalization of homelessness and engaging in policy advocacy to protect the rights of unhoused people. She is currently the directing attorney of housing at the Law Foundation of Silicon Valley and a board member of the Western Regional Advocacy Project and the South County Compassion Center. Finally, participating on Zoom is Paul Boden, the executive director of the Western Regional Advocacy Project. Paul became homeless at the age of 16. He began volunteering at a drop-in shelter in San Francisco back in 1983, eventually becoming program director there. He then worked as a case manager in a supportive hotel program for mentally ill people. Paul served as the executive director of San Francisco's Coalition on Homelessness for 16 years and was a founder of the Community Housing Partnership, a nationally recognized permanent housing corporation with optional supportive services. He served as president of the board there for 10 years and was also a board member of the National Coalition for Homelessness and the co-chair of its civil rights and grassroots organizing working group. Since 2005, he's been executive director of the Western Regional Advocacy Project, which is a coalition of local homelessness organizing groups based primarily in the Western U.S., but also working in alliance with similar groups throughout the country. Each speaker is going to have around 10 to 12 minutes. I'll be very aggressively calling time, apologizing for that in advance. And without further ado, I'm going to turn it over to Jeff, who's going to kick us off.
Hi, everybody. Good afternoon, I guess it is. Sure.
Is that right on screen? There we go.
Oh, right. That whole thing. Thank you, Michelle and Marlene, and the center and the initiative, and everyone else who had a hand in organizing this. And thank you all for coming. This is a really important issue, as you'll hear more in a few moments. One of the most important cases to go to the Supreme Court in decades on this issue. And there's so much to be done, irrespective of what the court does here, which you'll hear more of. As Michelle said, I'm going to provide some background about how we got here. I'll share the history of laws that have explicitly targeted and harmed people by race, class, and other traits, including their homeless status, but also laws that have implicitly punished people through proxies for these traits, but with the same intended and actual effect. I'll also describe modern era laws, what we sometimes refer to as new vagrancy laws, that target or disproportionately impact homeless people, including their growth and prevalence in California. I think that's one of the main takeaways I hope you get from this, is that these are actually not laws that have been around forever. The current iteration, move further. The current iteration, all right. These laws haven't been around forever. A lot of them are relatively new in California, and the creativity, endless creativity of lawmakers at the local and state level to find ways to punish homeless people. We're going to be out the door in a second. I should take a hint. Okay, anyway, let's get to the... So, first, some of the explicit laws. And this goes, I started this back in sort of the colonial era, only to let you know, there have been these kinds of laws for quite some time, going back to what were called warning out laws that were intended to forcibly expel people who were unwanted from communities. A lot of these laws that were explicitly race-based, and I note here sundown towns, and I should say a lot of the work on this has been done by Paul and Rapp and Tristia and others, pulling together this history, and a lot of it's in the brief they filed in this case. But sundown towns, which forbid people from being, as the name suggests, in town after sundown, almost always black, brown, Native people. The ugly laws, which actually started here in San Francisco, which were meant to exclude people with what were called unsightly disabilities from public. People didn't want to see people in public. There's been exclusionary zoning for more than a century. California cities were some of the first actually in the country to exclude people based on race from living or purchasing property in certain neighborhoods. Anti-Okie laws. This is post-Depression. This was meant to keep agricultural workers who were not originally from California from coming to California. The Okie was in reference to Oklahoma. Operation Wetback, which specifically targeted, and that's in quotes, that's what it was called at the time, which was specifically meant to exclude Mexican immigrants. So long history of explicit, what we call de jure discrimination against people based on race and class. There have also been a whole range of other laws that are, at least on their face, more neutral in some cases, but were designed with the same intended effects. So single-family zoning laws, which are meant to exclude people by housing type, so no multi-unit dwellings. Redlining, which were financial practices that discriminated against people based on race, made, for example, borrowing in neighborhoods that were primarily made up of ethnic and racial minorities, almost impossible. So-called urban renewal, which even at the time was critiqued as urban removal, which was meant to destroy low-income black and brown neighborhoods. And then on, sort of these downsizing laws, which eliminated housing units, almost 200,000 in San Francisco alone, and thereby driving up the price of housing. Massive cuts in the 1980s, and you'll hear more about this, to public housing. The Reagan administration cut public housing by 80% in the 1980s, but also cuts to public services. And even up to this day, cities, counties in California don't meet basic state targets for affordable housing. So lots of different ways to exclude people. What I mentioned earlier, that what we sometimes refer to as the new vagrancy laws, although they're probably best understood simply as anti-homeless laws, really emerged in the 1980s. This is connected some to what the courts are doing, which I'll talk about in just a second. But homelessness skyrockets in the 1980s, partly due to deinstitutionalization of people with mental illness in the 60s and 70s, but also, again, to the severe cuts to housing and services. 1982, we get this idea about broken windows, which is that, if there's one broken window in a neighborhood, everything goes to shit. And literally the authors say that includes what they call vagrants. So literally you leave one person, let them sit outside on a stoop, and the whole neighborhood can go to shit. In 1996, the Ninth Circuit upheld the first sit-lie law, one of the first sit-lie laws in the country in Seattle, which criminalized sitting or lying in public, full stop. And again, we'll talk more about what it means to criminalize, but fines, penalties, jail time, etc. That unleashes a slew of anti-homeless laws. I've categorized them here, I think as the National Law Center does, into these 4 buckets. One that are basically daytime activities, so you can't do these mostly during the day, standing, sitting, and resting in public spaces. A lot of them apply to evening activities. These are not exclusive categories. Sleeping, camping, and lodging in public places. We'll hear more about anti-camping ordinances in a minute. Begging and panhandling have been made unlawful, and even food sharing. So you can't feed people who are hungry. That's unlawful in lots of places. To give you a sense of this growth, in 2015, for the Western Regional Advocacy Project that Paul directs, we took a look at anti-homeless laws in the 58 largest cities in California. We were interested in seeing, have these laws always been here? Is this a new phenomenon? And here's what you can see. We literally just went into every local code under these 4 categories, and here's the growth in the laws over that period. You can see that 100 years ago, these laws basically didn't exist in these 4 categories that I just showed you. Today, in all 58 cities have laws in the first 3 categories. This was early on. This was almost 10 years ago, so this was early on in the criminalizing food sharing. That number would be higher today if we had more current data. And all told, 592 laws in 58 cities. So anytime an individual law was struck down or had to be put on hold because of a court case, there were plenty of other laws that could be used. It's really important to reiterate that. The case we're going to talk about is about anti-camping laws, but there are a gazillion laws that can be used to punish and move along homeless people. Why do all these laws matter? Because we've got, as you know, a big homelessness problem in California, or a big affordable housing problem in California that leads to homelessness. These are just some basic facts and figures about housing precarity and the number of homeless people in the state. We'll share these slides, I presume. So, just last little bit before I turn it over to Tristia. The Supreme Court has gotten involved in these issues over the years. Some of those laws I showed you at the beginning were either changed by policymakers and lawmakers, or the Supreme Court struck them down. So exclusionary zoning laws were struck down more than 100 years ago. California's anti-Okie law was struck down. Residency requirements for welfare, one way that places tried to keep out poor people was to say, if you move to our state, you can't get any public assistance for a year or more. This was adopted in state law, but it was a federal law, and it was struck down in 1969. 1972 and 1983 are kind of big moments in this story because the court strikes down both vagrancy laws and loitering laws as being too vague and giving police too much discretion. One of the reasons that we get the spate of laws then later in the 80s and 90s, Seattle sit-lie law, is because cities need to more narrowly tailor what it is that they're punishing. And that's how we get to Grants Pass, and I'll turn it over to Tristia. Thanks.
Hello, everyone. Again, my name is Tristia Bauman. I am currently the Directing Attorney of Housing at the Law Foundation of Silicon Valley. I want to start by shouting out Robert Aguirre, one of the founding members of the Gilroy Homeless Union. And I am going to advance the slide. So we're going to talk about Grants Pass, building on... Ooh.
I was just using the keys down here.
I am always the one to screw up the tech. So building on, thank you for troubleshooting. You might have, there we go.
There we go.
Now click on it. The keys work. Okay, great. Thank you. So building on the legacy of excluding marginalized people from public space and using our criminal legal system to penalize them on the basis of their identity, we come to the modern era, and we'll talk about it in the context of Johnson v. Grants Pass. This is beautiful Grants Pass, Oregon. And like every other place, including, this city, it inherited the legacy that you just heard Professor Selbin describe to you. It also, like every other place in the United States, is currently experiencing an unsheltered homelessness crisis. There are not enough locations where people in Grants Pass can afford housing. And there is nothing in Grants Pass that we would recognize as an emergency shelter, a place where somebody could show up and receive shelter, even for a single night. Also, like so many other places, you heard about in California the number of cities that have camping bans. Grants Pass is one of the 3/4 of cities across the country that have camping bans and laws on the books that make it virtually illegal to exist as an unhoused person. So what I'm about to show you next are shocking images of illegal activity. In Grants Pass. Oh no, the images disappeared. I'm so sad. Well, it was a person sleeping. And that person was sleeping on a public sidewalk, street, or alleyway at some time, and that is illegal.
There.
Yes. Also, it is illegal to occupy any place where bedding, a sleeping bag, or other material used for bedding purposes is placed in public space. I would like for you to notice the cardboard. That is illegal. The blanket. That is illegal. And no, there is not an exception for weather. So disregard the snow on the ground. It is illegal to park your vehicle overnight in a park. And if you violate park regulations, then it is illegal to be at any time in any park within the city for a period of at least 30 days. And if you violate that, that's a trespass ban violation, which is a criminal penalty, and you could go to jail. So a class of unhoused people in Grants Pass, Oregon, decided to challenge this patchwork of laws that made it illegal to live outside. And one of the primary arguments that they used was the Eighth Amendment's cruel and unusual punishments clause, the enforcement of these laws against unhoused people who don't have access to housing or shelter were facing cruel and unusual punishment. So let's talk a little bit to give some context as to what we mean. The Eighth Amendment applies to all of us. We all have this guarantee of freedom from cruel and unusual punishment. But what does that really mean? Well, the Supreme Court has said in Ingram that the Eighth Amendment circumscribes, limits how the criminal process may be used in 3 ways. So first, you need to have punishment. And there's a limitation on the types of punishment that the government may impose. For example, they can't sentence you to a torture device. It prescribes punishment that's grossly disproportionate to the severity of the crime. And arguably, any law that criminalizes a person for living out the universal consequences of being a human being, doing the things we're all doing right now, resting, standing still, sitting down, is grossly disproportionate to the offense. But it's the third prong that courts have interpreted in the context of laws criminalizing homelessness, and that is the limitation, substantive limitation, on what governments may criminalize in the first place. The seminal case interpreting the limitation on what governments may criminalize is the case Robinson v. California, and that dealt with a law that made it illegal to be addicted to narcotics. And the court rationalized that you could become a person who is addicted to narcotics without ever having done anything that we would recognize as a criminal offense. You never have to possess it, sell it, have anything to do with narcotics. You could be born into the status of addiction, and that was an invalid statute under the Cruel and Unusual Punishments Clause. Following on Robinson, in the next Supreme Court case to look at that third limitation is Powell v. Texas. And this is a case that looked at a law that made it illegal to be intoxicated in public. And the argument was, in that particular case, there are people who cannot resist intoxication. They're alcoholics, it's a disease. So to criminalize them for being intoxicated in public is akin to criminalizing their status as a person who's addicted to a substance. Now here's where the jurisprudence gets a little shaky. A plurality of the court said, no. Robinson is about status. This case involves conduct. Being intoxicated in public is conduct, and that's just that. Robinson doesn't apply. There was a fifth justice who concurred in the judgment, but disagreed with the rationale. And in fact, in dicta, Justice White said, for a person who's unhoused, who can't resist being intoxicated by virtue of their addiction, and also can't resist being or avoid being in public by virtue of their homelessness, this may be invalid as applied to them, but that's not the facts of this particular case. And of course, 4 additional justices dissented. And it was the combination of the rationale of the dissent and Justice White that formed the basis of the first Ninth Circuit case that looked at criminalization of homelessness. That's Jones v. City of Los Angeles. And just in the interest of time, I will say that challenged criminalization of homelessness in Skid Row in Los Angeles. It resulted in an opinion that found the Eighth Amendment is violated when laws are enforced against unhoused people in the context that it was in Skid Row. But that decision was vacated pursuant to settlement. So it was followed by another decision, Martin v. Boise. You've probably heard a lot about this, but suffice it to say, Martin formed the underlying basis upon which the Johnson case was built. And how many minutes? I've got 2 minutes, maybe?
2 minutes.
2 minutes. So I'll take 30 seconds to say something about Martin. Martin involved 6 individuals that had no practical access to shelter. So this was not a case about housing. This was a case about access to shelter when they were faced with punishment under a disorderly conduct law and a camping ban that criminally penalized them for being outside. And what the Ninth Circuit found is that so long as they have no option of sleeping indoors, they cannot be criminally punished for sleeping outdoors. Following Martin, the Johnson v. Grants Pass case was filed. This was a little different from Martin in that it was a class action, a little different in that it involved a patchwork of laws as opposed to a single ordinance that applied citywide at all times. It also expanded and expressly expanded Martin just a little bit in that, you can also use a blanket. It's also cruel and unusual to impose a civil penalty that results in a criminal penalty. And the government's response was as follows. The sky is falling. How can we possibly handle the growing crisis of homelessness if you are tying our hands? If we can't use the criminal legal system or tickets to order people along, then you are essentially saying that there is a right to camp in public space and that we can do nothing to respond to the growing complaints from citizens who are justifiably upset about the number of people living outside. Some of the response was to prop up, as the mayor of San Jose is recommending that we do now, prop up interim temporary shelters, or to establish, here they're being called safe sleep sites, but sanction encampments so that there's a place where somebody can go. You're not involuntarily in public space if there's a place where you can go. Path to SCOTUS. There has been an organized effort to get the Martin decision and now the Johnson decision reviewed by the Supreme Court, and it in fact is being reviewed now. There's been an organized amicus effort, including by numerous governments. Our own governor has submitted an amicus brief in favor of review, and as well as other stakeholders, police, business interests, and a policy institute that's funding a lot of this, the Cicero Institute. What they're asking the Supreme Court to do is really review a question that is essentially presents a legal fiction. Should generally applicable laws regulating camping constitute cruel and unusual punishment? But these generally applicable laws are not enforced against the general public because the general public isn't living outside. It's people who don't have access to other locations who are living outside. And what they're arguing in Grants Pass specifically is, look, this third prong, what can be criminalized, that is some strange outlier. Robinson is the only case that ever said anything like that. The original meaning of the Eighth Amendment is to limit the how things can be punished, not the what can be punished. Governments should be able to regulate what they want to regulate. So these are the folks who are going to decide some very important things. Now, this case is about criminalization of homelessness. But it's really about the criminalization of any unpopular status. Is that constitutional under the Eighth Amendment? What about, okay, fine, not status, but if it's about some act, sure, maybe it's not one you can avoid doing if you have a certain status, but we're not going to say it's because you're homeless, it's because you're living outside. What does it mean about whether or not we can evolve our standards of decency, or whether we're stuck in a world to whatever was decided in 1776 is cruel is the limiter on what is in fact cruel? We'll see. Oral argument is next Monday. Thank you.
Thank you. All right, we're going to switch over to our virtual presenter, Paul. Okay.
You ready?
And if you have questions in the meantime, hang on one sec, Paul. We're going to get your face on the screen. And if you have,
want to do that.
Oh no, it's such a beautiful face. Oh, there we go. I see him in the background. Yeah. There we go. There we go. Awesome. All right, I'm going to give you a heads up at 5 minutes, okay?
Right ahead, Paul.
All right. Hey, everybody. Sorry I couldn't make it down there today. We're a little busy with, got a 14 or so cities that are all doing actions simultaneously on Monday and just a little crazed. But I am glad to be here and to be with Tristia and Jeff and with the school. I think the first thing I would want to say, just to give some context to this, is when we look at this case or we look at the Supreme Court hearing on Monday or listen to it, whatever the fuck they're letting us do, that we understand homeless people ain't the first targets of these laws. You know, when you talk about the ugly laws, the sundown towns, the Antiope laws, all the Japanese American Exclusion Act, all the stuff Jeff was rapping out before Like the program, the names of the programs change, but we haven't yet accomplished the goal of actually changing the laws itself that make up what it is we're talking about, which is basically standing still, sitting down, being present. If you're present in a community that has decided we don't want LGBTQ people in our town, we don't want black people in our town, we don't want brown people in our town, we don't want homeless people in our town. The ugly laws was about disabled people. If you are so maimed and mutilated as to be deemed unsightly, we can criminalize your presence. And this has never been addressed because the power brokers, the people that write these fucking laws, are the same kind of human beings then as they are today. They're white, genocidal, elitist, entitled. The people writing these laws break these laws. And they know it when they write them. But they also know goddamn well it's not going to apply to them. And then we keep going back to the courts and back to the courts. We document their activities, their atrocities. They're dehumanizing us. They're criminalizing our presence. And then we go to the same white colonial court system to try to find justice. And that's where so many of us are just absolutely fed up with this whole game of being studied. Are you left-handed? Are you right-handed? We're going to coordinate the intakes. Have you ever had a felony? Where were you born? In order to get a housing unit or access to treatment or justice in court. Your disability status. If you're arresting me for being in public space, and we talked to 1,800 people, and we didn't give out trinkets, we just talked to our community members, our friends. And of 1,700, people, 82% have been harassed, 51% cited, and 31% arrested for the act of sleeping. 75%, 44%, and 26% for the act of standing still. They call it loitering. Do you think any of those people were mom coming out of a Barnes and Noble store with their little kid having an ice cream on the sidewalk? I certainly don't. These laws are targeted to remove a segment of the community that the people in power in that community have decided they want to get rid of. And it's gotten so aggressive around the issue of homelessness because we're so visible. And for 41 years, I've been working in these freaking fucking homeless programs. And it started out as temporary emergency shelter facilities. 41 years later, you can't consider that a temporary emergency response. We've created a tier of housing, and we've created a whole intake and coordinated process and homeless management information systems and point-in-time head counts to validate the system that was created to not end homelessness, not address what created homelessness, but to mitigate the visual aspect of the fact that homelessness exists, which means we're being dehumanized. It's not about how we as human beings are being forced to live in a community or in a city or in a town. It's about the fact that others have to see us. And when you look at what created the situation, this is the cuts to affordable housing under what they called the Reagan Revolution, and then they turn around and name a freaking airport after the guy. And you see the absolute causal nature of how did it happen that in 1983, we know our DNA didn't change. We know that a bunch of us didn't decide, oh, this living inside a domicile is so yesterday. I think from now on, I'm going to go live my
I'm giving you a
out.
5 minute. There you go.
That's, oh, I got it. I got a little clock here and shit. I got it. So we know that it wasn't a DNA influence, that there were systemic reasons why this happened. And since 1994, in addition to those massive cuts I just showed y'all, we've documented now, and this is where the research aspect is so important, is to make sure that your research is driving the organizing in the community in order to achieve systemic change. And Jeff and his group and Seattle University with Sarah Rankin have been really awesome about facilitating the process of doing research to drive changing the system of oppression that people are experiencing. With business improvement districts, same thing. So, like, we know what created the situation, and we know that you can't, I was saying the federal government's destroyed 487,000 units of public housing just since 1994, which was 13 years after we started homeless programs. You're gonna be putting more people out in the street. Those units were not sitting empty unless it was so massively neglected. Instead of fixing it up, they sold it off. So you're actually deleting and demolishing the affordable housing that's needed to address homelessness. And now you're going into the Supreme Court to say you need to make it easier for us to be able to disappear these people. And the understanding has to be, we're not talking about homeless people. Homeless people are today's target. We weren't the first, and we sure as hell won't be the last. So all of us need to come together with our legal skills, with our academic skills, with our artwork skills. You can't have a party and you can't have a revolution unless you got kick-ass artwork and music and theater. And all of our beauty and talent needs to come together to coalesce around a human rights context to everything that we do, whether it's on the legal front, the academic front, the organizing front, or the artistic front. It's about having a fucking party as a people and celebrating our existence and not letting anybody try to get us to cease or desist in our right to exist in public spaces, because there are goddamn public spaces and we have every right to be here. Thank you.
Well, thank you so much, Paul. I'm torn between wanting to put your poster up on the slides, but I think I'm going to just keep your face there. And then at the close of the program, you have to see the poster for the, there you go. There's also a protest, a big protest happening on Friday. Do you want to say a little bit about?
Yeah, put it up. Put it up. Jeff made the slide.
Do you know how to make that?
You don't want to be looking at
it's
my
beautiful. No, we want your face.
Just 1 second.
Yeah, come on up to San Francisco, everybody. We got all these Bay Area groups coming together, and we're going to have a party, a celebration, and kick some ass.
Yeah, it's fantastic. That's great. All right. So while we figure out how to get your face back up here, I'm going to ask a sort of a question I think that's targeted for our lawyers, which is if grants pass wins, if the town wins, what's the impact, if any, that you can see on the plan going forward for the movement of folks that are advocating on behalf of homelessness or against attacking the homeless? And also, how do you see that decision, if it comes down that way, impacting folks who are unhoused here in Santa Clara County?
Can you all hear me if I got on the mic?
I think you might have to push the button.
Again. There we go. Well, we're already seeing it have an impact. So even the fact that it's being reviewed by the people it's being reviewed by is, I think, emboldening cities to enact new laws that they have been hesitant to enact. Speaking very locally here in San Jose, within the last couple of weeks, 2 laws have just been enacted. One makes it illegal to sit down, lie down, sleep, or store property, which can be interpreted as like possessing something and putting it down in public space within 150 feet of all schools throughout the entire city. Another law enables the city council to determine or the city to determine different areas that can be posted with signage saying it's illegal to park a vehicle that is of a certain volume. It's mostly targeted at RVs, but wouldn't exclusively be enforced against RVs in any location throughout the city, and violating that ordinance would authorize government to immediately seize and impound that vehicle. And if you're a person living in that vehicle, that means as a practical matter, it's permanently lost along with all of the stuff that was included within that vehicle. And this is before we're seeing, the decision. If they decide that the Eighth Amendment, which has been one of our strongest tools, is no longer available to challenge enforcement, essentially what that means is regardless of whether or not a person has any choice but to be outside in the location where they are, they can be criminally punished for that activity. So, will that lead to a worsening of the mass incarceration that we're already seeing of people who are in poverty? I would suspect so.
Thank you, Tristia. I'm also interested to hear Paul's sense of where this is all going to go. I know that's Paul and groups like the one Paul runs are the ones we take our direction from. I think that's actually really important for any of you lawyers out there or lawyers to be. I want to go back to something Paul said, which is that the courts are not going to save us, even if the courts actually uphold the law in the Ninth Circuit. That's not going to solve the major problems here. Just to give you some sense, I happened to listen to a podcast on the way up about Grants Pass, just a little bit more about implementation of the settlement there. People can sleep in parks for 3 days, and then they have to move. And if they don't move, under the settlement in the case, they're still punished. And you're talking about many people who are disabled and whatever. It is an enormous thing to say you have to move every 3 days. So the status quo is not tenable or sustainable. I agree that it will be worse, and only in the sense that we'll be back to you can do just about anything. There's no limit. We don't live in a country where our political system or the courts have ever said that there are substantive rights to housing and food and even healthcare. So that's the backdrop against which all of these, I think, fights will continue. And I think organizing, mobilizing, doing what you can in your community are going to continue to be really important. But Paul, I'm just going to kick it over to you.
I look at it like, absolutely, it's freaking sad we're sitting here talking about how are we going to defend the status quo, because it's been pretty brutal, and it's been pretty brutal for a long time. But I also think when we think about the issue of homelessness and how it intersects with so many other issues, is people need to get really educated and understanding in a broad context just what neoliberalism is and how we tested it for years in South America and Central America, where they didn't have local police departments, they had militaries in order to implement the systems of neoliberalism as we were testing them out down there. And we called them banana republics because the Chiquita Banana, or United Fruit Company, was such a big part of the experiment. But the Reagan Revolution was bringing that to the forefront in terms of American political systems. And the politicalization of our court system, there's the People's Parity Program, and there's a bunch of other groups that have tracked the history of the right-wing takeover of our judiciary system. And that's stuff that we tend to think, oh, well, we're just talking about panhandling laws or whatever. Like, we have to do our organizing and do our research and do our public education work in the broader context of what it is that's really at the core. Because when things like public parks become commodities, which they surely have, and this is not Democrat or Republican. Nancy Pelosi talked about how we had to commodify the Presidio because the public park had to pay for itself. And our schools are just straight up commodities, and our housing with low-income housing tax credits and housing choice vouchers are all about incentivizing the private market to provide housing for poor people. So, of course, the poorest of the poor are left out of the equation, and 90% of the affordable housing being built is 90 to 120% of median income. So we have to understand that, and certainly in our healthcare system, and look at a lot of other countries, we know how fucked up and neoliberal our healthcare system is. And you know, the fact that having a healthy, well-educated, well-housed community is somehow a threat to the people that are running the political system that we have right now is why we keep seeing these overlapping forms of oppression and the rise of fascism yet again in the United States. People forget there were 300 Nazi summer camps in the United States right before Japan bombed Pearl Harbor. So don't think it's not in the DNA of this country. Hell, look at freaking Donald Trump and shit. Like, fascism is rearing its ugly head, and we need to get educated and artistic and engaged in our community in order to truly combat this and make some serious systemic change. The court ain't gonna do that for us. We have to do it for ourselves.
So just to be like really concrete here, the day after the Supreme Court decides in favor of Grants Pass right to enforce some of these ordinances, what happens to folks who are unhoused there? Like, what exactly would that future look like, do we think?
The same shit that's happening today, it'll just happen a lot quicker and a lot more aggressively.
Yeah, I'd agree with that. I mean, I don't think that there is an army of police officers that are just, being held back, waiting for the decision to be rendered, and will the next day, go out after people. But what I think it does is enable the ability of governments to respond to complaints. So there's some great research showing that a lot of the criminalization of homelessness is complaint-oriented policing. And so people want to respond to the complaints, and now they will have a lot greater freedom in how they respond to our harm. Yeah.
So this is an audience that has in it some very practical folks that want to know what we can do to help right now in this moment, the unhoused community locally, or as lawyers and lawyers-to-be, what we can do to plug in to try to make a difference and push back on this.
Paul, do you want to start us off? Because I feel like you are the best person to start us off.
Yeah, and Paul, maybe if you haven't already said something about the legal clinics that you guys have.
Yeah, I mean, and the first step, so Tristia, a hot shit person named Alex, Jay, a bunch of people put together a different way of doing the combination of community organizing and legal representation for people that are being oppressed. And the first step in that process was to do outreach to the people in the community about what their priorities are, which means you have to document the outreach and you have to then coalesce it into, all right, if 80% of the people we're talking to say this is a priority, then this is a priority. So you get your marching orders from the actual community and not just, oh, I talked to like 10 people, but like I mentioned before about how are these laws impacting you, we talked to 1,700. Recently around the issue of housing in Denver, the House Keys Action Network in Denver, Colorado talked to 800 unhoused people in order to facilitate an organizing and research campaign around trying to increase access to affordable housing in Denver. So the first step is who's we, and what are the priorities that the community has identified, and then what skill sets do we have? When we did it within the legal community, it was with lawyers. And it was like, how do I make sure that the legal work, and we just used this process in writing the amicus brief that we submitted to the Supreme Court, where the lawyers did the legal stuff and the writing and the formatting that the court had to have the shit in order to accept it. The organizers, Joe May here and others, like made sure that what the lawyers were writing and researching and documenting for the legal brief was coming directly from the community. And that's the process of building collective power, because then both sides say, hey, we did this. We did this together. We wrote the Right to Rest Act after those 1,700 outreaches with Tristia and Jeff and other legal experts so that we could craft our own legislation to try to stop the way that these laws are being used and enforced against us. And every city, every police, we ran it 11, and we'll run it again, I'm sure, but 11 times we've run that bill in 3 separate states. And we've gotten our asses kicked 11 times in 3 separate states, but it's still one of the most powerful organizing tools that we've ever created. And we created it collectively based on the street outreach of our community members in order to identify our priorities.
I'll give a local example that some of the students are already working on. So thank you very much to the Unhoused Initiative and to Sonia McKenzie's capstone students that are helping to build out some of what Paul talked about. So that hand survey that he mentioned in Denver, we took that survey and did a modified version of it in Gilroy with members of the Gilroy Homeless Union after Gilroy enacted its own camping ban. And we were in the parks talking with people, going through and creating a survey instrument that asks people, what are your connections with this community? What are the things that you would need, both permanently and temporarily? And what are the rules that would make something accessible to you or inaccessible to you? Along with some questions about the harms being experienced. Being part of that effort has allowed us to meet on a weekly basis and do things now as a Gilroy Homeless Union. We're doing events. We have a capstone project that is going to produce a policy report that we're going to use to lobby the city government. And meanwhile, we're building up a power base of people who are unhoused, who have not had a voice in the city of Gilroy, who will have a voice and be a known and powerful, armed with knowledge, advocacy entity in South County. That same effort could be done here in San Jose. And of course, locally, there are other things that can be done, including now. You don't have to wait until you get your law degree. The ordinances that I just mentioned are going to result in an opportunity to represent people in administrative hearings. And you can do that as a student, and you can do it using the model that we call the Legal Defense Clinic model that RAP and the Law Center co-developed. You can do it. So those are some things you can do.
So I know we have a hard stop at 1, so I want to invite those of you who have an inkling that maybe this is something you'd like to find out more about or plug into. One of the sign-up sheets, the one that's right at the corner there, will get you on the Unhoused Initiative's mailing list. And we're largely, it's not like a mailing list that's going to give you stuff in your inbox. We actually operate as a clearinghouse. So we try to figure out what you're interested in, and we put you in touch very quickly with folks that are doing the work locally. And our mentors who are in the region are of enormous service. And so many hands, less work. Really, I want to encourage you to be involved in whatever way you might feel called to do. We also have, as we're getting ready to close out, our signature homemade cookies. Sorry for those of you attending on Zoom. Marlene is an incredible baker. So stop by and grab a cookie. To access the slides and the fantastic legal brief that Paul and Tristia and Jeff actually all had a hand in, that's actually both on our website, so the resources tab within the Unhoused Initiative. It's also in the MCLE materials that you'll receive if you were signed up for that. Thank you so much, and let's give a round of applause to our speakers.
I wanted to say that's also up on our website, rap@raphome.org.
Say it again, Paul.
Raphome.org is our website. Everything I've talked about is on the website, and it's all downloadable for free.
Thank you so much for coming out, for sharing your lunch hour with us, and really, Godspeed.